No problem.
They're all good to record. You've definitely
Yes,
they're all good.
Yep, we're going to record.
They're all flooding in.
Yeah, 60 people.
Do you want to mute that?
Okay,
We're
let's
just
go.
going to mute and then. Oh, you're going to say hello.
Yep.
Yep. What?
Yes, I'm going to say hello.
What are you saying? Yep to?
Okay.
All right, admit all. Here we go.
Hi, everybody. We're just
Hi
letting in the crowd. Obviously, we've got a very exciting session on today. I'll just wait another minute to let everybody in because there's quite a few. All right. All right, we might get started. Welcome, everybody. On behalf of Lisa, Georgia, Baxter and myself, we welcome you to our 14th Lunch and Learn this year.
Wow.
Which is amazing. And we're just going from strength to strength. And I'm just thinking that today we may break the record number of people. So kudos to the topic, I think, which is a hot topic at the moment for all of us. That's for sure. So today's webinar is hosted by COWELL CLARKE. It's on mastering the new franchising code and looking at a practical overview of the proposed changes. So the COWELL CLARKE commercial lawyers, firstly, are member plus or associate members of the FCA and have been members for many, many years. And they've got a national specialist franchising team, of which Megan and Karina, that you're going to hear from today, are part of. So COWELL CLARKE's innovation arm, Verimus, also has a franchising portal that eases the burden of franchising compliance in one easy platform. So without further ado, let's hear from Karina. But whilst Karina is talking, if you've got questions, please type them in the chat and we will get to them. We'll leave at least 15 minutes at the end of this session for Q&A. Thanks, Karina.
Okay, thank you so much, Helen. Firstly, I'd just like to start by saying a very big welcome to everyone listening. And thank you for joining us in your lunchtime for what promises to be a succinct but hopefully useful talk about what are the new changes which have been proposed to the Franchising Code of Conduct, and also give a bit of a practical overview about how they will work in operation. As Helen mentioned, both myself and my co-presenter Megan Youngblood are lawyers at COWELL CLARKE, and we are part of the firm's specialist franchising team. Megan is a director in our commercial team. She does predominantly commercial work and compliance in her practice. There's a lot of franchising work as part of that. And my role as an associate director is mainly focused on the areas of commercial litigation and dispute resolution. So Megan and I are both very excited to be here today and talk about what Helen mentioned is a very hot topic, given the proposed changes to the code. So let's go ahead and get into it now. Today, the way we'll structure this session is to firstly talk a bit about the background and the timeframes for implementing the changes which are proposed in the exposure draft of the code. And we'll then give a bit of a blow-by-blow account of what those key changes actually are, as well as an overview about what they'll mean to the industry from a practical perspective. We'll then finish up at the end with the opportunity to ask some questions. But if you do think of something later that you'd also like to ask, and sometimes that happens, feel free to either email myself or Megan, and we will do our absolute best to get back to you with an answer quite quickly. Okay, so we'll just start off with a bit of background as to what these current raft of changes are all about and why they've been happening. Well, it's important to firstly note that the current proposed changes are still in draft, and so they've not yet been finalised into the legislation. But that said, I would think that it's be fairly likely that there won't be much or if any further tinkering to the form of the exposure draft that we are seeing at the moment. As for the code itself, well, some of you may remember that it was introduced originally around 27 years ago, back in 1993. And since then, it's continued along in various forms and undergone 8 different rounds of amendments. So what that history very clearly tells us is that the code has really been quite a dynamic instrument, and that could perhaps be said to reflect in general how franchising as a business model has also evolved quite a lot over that time as well. Now, this latest review is actually critical for the code to be able to continue to operate, because the current version contains a sunset clause, which is due to take effect on 1 April next year, if it's not remade before then. And that's the same date that we can expect for the new code to also then take effect. Many of you will also know that the current draft arises out of the independent review, which was undertaken by Dr. Michael Shaper last year. His report was then released in February, contained 23 recommendations and 34 suggestions. The government responded in May to accept all of the recommendations from the review, and the exposure draft was then released in early October. This was then followed by a relatively short consultation period of roughly 3 weeks, which just closed recently on the 29th of October. So let's take a look at what those changes are now. So the first change which arises out of the review recommendation was that the code should include a new and very clearly stated purpose. Now, the current code does already contain a purpose, but that is simply to state that it is to, quote, regulate the conduct of participants in franchising. Now, you're probably thinking that's not only very brief, but also really just states the blindingly obvious. And if so, well, I would agree with you completely. But what's proposed now is clearly a much broader and more detailed statement of purpose, which expressly states that there are 3 critical aspects to its operation. The first one is that the code will seek to address the imbalance of power between franchisors and franchisees. And that's probably an unsurprising point of concern, given that that's also been the focus by the courts in quite a number of recent cases, which have dealt with various allegations against franchisors, some quite well known, relating to things like inadequate disclosure, misleading and deceptive conduct, and the breach of the obligation to act in good faith. The second part of the purpose is for the code to try and improve the industry standards of conduct and practice, particularly by achieving better disclosure of information by franchisors. So together, these 2 aspects are really about the government trying to show that they're doing everything possible to even out the playing field between franchisors and franchisees. In doing this, it's hoped then that this will improve the standard of compliance at the industry level and reduce the need for intervention by the regulator and the courts, particularly with the type of cases that I just mentioned. And finally, the last part of the stated purpose is to provide a procedure for resolving disputes which is considered to be both fair and equitable. So what we can see from this new purpose is that it's obviously a lot more comprehensive, but also that it gives us a really good flavour for what the particular objectives are that the code hopes to achieve, and the starting point from which the courts will view and interpret certain provisions in the case of any litigated proceedings. All right, so the next change arises out of the expectation expressed by the government that going forward, the code will undergo mandatory reviews every 5 years. And that's so to ensure that it continues to operate efficiently and effectively and to deliver on its newly stated purpose that we just talked about. Now, in line with this expectation, the proposed regulations will include an express requirement that the next code review must commence before 1 April 2030. And you might notice that that timing also coincides with the next sunsetting process. Now, given that historically the code's been amended on average around every 3 years, this expanded timing will hopefully add a bit more stability to the industry, but especially for franchisors who, of course, bear the main compliance burden and so also feel the greatest impacts, both practically and from a cost perspective every time that changes are made. That said, however, this doesn't necessarily mean that the government can't or won't make further changes before then, but given that this last review was quite comprehensive, there's an increased likelihood that the next 5 years could be a relatively stable time period for the code. So we will watch this space and see. Right, so the next change is quite an important one practically because it is to remove or is so-called merge the existing with the disclosure document, the existing requirement for franchisors to provide a key fact sheet as part of their suite of disclosure documents given to franchisees. Now, you might recall that the key fact sheet first came out as a requirement back in mid-2021. And so this was a relatively recent obligation that hasn't really lasted all that long. But the government has explained that the reason for this change is because since the establishment of the Franchise Disclosure Register back in November 2022, it's meant that the information in the KFS was essentially just repeating what was already disclosed in the register. So the KFS wasn't really offering franchisees any practical benefit in terms of disclosure, and this means happily that for franchisors from franchisors from April next year, they should no longer have to create, maintain, or provide the KFS to their franchisees. Note just also that the government has said that any extra information contained in the KFS that's not also in the register will then need to be added into the disclosure document. So that is the merging aspect of the merging of the two documents. So this is to ensure that no information will be lost when the KFS is scrapped. Now, currently, it seems that the only information which falls into that particular category is the disclosure of whether the franchisee could face competition from any businesses that are not associated with the franchisor. So franchisors, you'll just need to ensure that you add this particular information into item 9 of your disclosure document by the time that the new code takes effect. Okay, so the next changes are again quite important because they relate to opt-out provisions. Now, the government has acknowledged quite sensibly, I think, that the risks which arise from inadequate disclosure are significantly less in cases where there is an existing franchisee. And this is the reason which underpins these proposed new opt-out provisions. So the first changes in sections 22 and 23, subsections 4, together provide that where an existing franchise agreement is to be renewed, extended or transferred, then those franchisees will be able to opt out of receiving the disclosure documents. Similarly, changes to subsections 47.7 and 49.4 will mean that existing franchisees who are entering into a franchise agreement, including by way of transfer, will also be able to opt out of the 14-day cooling off period, which allows them the right to terminate in that time. Now, a couple of important points to note. Firstly, existing franchisees can only use these opt-outs in circumstances where they have been a party to another franchise agreement with the franchisor, which is the same or substantially the same, and so this is in addition to, not in the alternative, the franchisee's business likewise is the same or substantially the same as the one which is the subject of the new agreement. So one example scenario where this could apply is where a franchisee has a physical location for the business, such as a bricks and mortar store, and that location changes, but the business remains the same. In that type of situation, the franchisee could then opt out of the cooling off period, which would then allow them to step into the business and start running it straight away. The second thing to note is that these opt-outs don't apply automatically, but only when the franchisee makes a written request to the franchisor. So it's not enough, therefore, to have a chat and for the franchisee to say, look, don't worry about the documents, I'm fine, or don't worry about the cooling off, I'm really not concerned about it. These opt-outs must actually be put in writing to the franchisor. A couple of other brief observations. Firstly, even where a franchisee does opt out, they will still retain the right to request a disclosure document under sections 31 and 32. So if a franchisee later makes that request, the franchisor must still meet its obligations to provide the documents, notwithstanding any earlier opt-out. And lastly, I'll just note that the code doesn't actually define what is meant by substantially the same or recently. And because these terms are very much open to interpretation, it's possible that the uncertainty around their meaning could perhaps then lead to disputes or complaints later on, particularly if there's an acrimonious franchisee who's looking for a reason to argue that they should be able to get out of the agreement. So even though the intention behind these changes is to simplify and reduce the disclosure obligations, some franchisors may consider that practically it's not really worthwhile them incurring the risks of firstly disrupting their settled disclosure processes, and secondly opening up these possible arguments later on down the track. Therefore, to be prudent, some franchisors may still decide that they want to insist on providing the disclosure document or waiting for the cooling off period to pass, just to err on the side of caution, even with an opt-out. But of course, that will depend on a range of factors, including the franchisor's appetite for risk and whether there's a history of disputes with any particular franchisee. Okay, I'll just hand over now to Megan.
Thanks, Karina. Now, Karina's driving the slideshow, so you'll hear me say thanks, Karina. That's her signal to change the slide. So I guess we'll now turn to, I think I've probably got some of the more controversial changes to the draft code, arguably, to work through now. And I'm conscious of time, so I'll do it fairly efficiently, but please ask questions at the end if you think I've skipped over anything too quickly. So the government response recommended that the termination provisions relating to termination of franchise agreements are simplified. So this has led to the introduction of Section 54. I'll take you through the effect of 54. One does query when we get to the end as to whether or not this process, the termination process, actually has been simplified. I think for franchisors, it may have actually become a little bit more complex. But anyway, this section allows franchisors to terminate with 7 days written notice without the right of the franchisee to request that dispute resolution process to be enacted. And this applies where a franchisee no longer holds a licence that's required to carry on the franchise business, it becomes bankrupt or insolvent, it is deregistered if it's a company, it's convicted of a serious offence, or it's found to have committed a serious contravention or offence of the Fair Work Act or Migration Act. So as you could appreciate, with these various serious contraventions, essentially a court process or a process by a competent authority would have already occurred. So that's why the thinking is we don't want, the franchisee shouldn't avail itself to a further dispute resolution process to essentially delay the termination of the franchise agreement. So that's the simplification aspect, I guess. If there's already been a process followed on one of those serious breaches, then all the franchisor has to do is give that 7 days notice. It is important to note that these grounds need to be specified in the franchise agreement. This is not an additional right that sits outside of the franchise agreement. So certainly franchisors will need to review their template agreements before the commencement of this code to ensure that they have specifically addressed these grounds for termination to rely on that 7-day notice. It is important to note, and this is where I think it does get complicated in one sense, we have Section 55, which deals with less serious breaches by franchisees, and that process still enables a franchisee to challenge a termination or breach notice. So essentially, franchisors are going to have to make a decision during the termination process. Does this fit within Section 54? Am I safe to just issue that 7-day notice and progress with the termination, or does this sit within the Section 55 categories of breaches? So that's why I say I understand the intention behind this section, but I do think overall it has complicated things slightly for franchisors. Right, change slide, please, Karina. Thank you. So this brings us to probably one of the more controversial changes introduced by the draft code. Section 43 essentially is there to ensure that franchisees have a reasonable opportunity for return on investment. This section expands the scope of existing Clause 46B of the existing code, which currently only applies to new vehicle dealership agreements, and essentially it now applies to all franchise agreements. Franchisors are not expected to provide a contractual guarantee of profit or the success of the franchise business. It's not intended to remove the inherent risks of running a business, but rather it's intended to ensure that the term of a franchise agreement is consistent with the level of capital investment required. The issue with this section is it's really unclear how a return on investment is to be measured, and you query whether a benchmark should or will be developed, and hopefully for all of us, maybe not so much for the lawyers, we might hope this is the case, but we don't want it to be developed through case law. And it means franchisors will need to turn their mind to the tenure of the franchise agreement and the likely costs incurred by the franchisee to determine whether the franchisee essentially has a reasonable opportunity to make a return on investment. So I think the practical result of this is that it will result in longer terms of franchise agreement to mitigate any risk of the franchisor failing to meet this obligation. Now, that in itself may in fact bring further risks to both the franchisee and franchisor, especially when the franchise is not overly profitable for a franchisee. So they may get a return on investment, but at the end of the day, how profitable is that franchise for them? And they're then stuck in a longer term agreement. Now, franchisors will certainly need to undertake financial modelling to determine whether this requirement has been met. And I think the temptation, maybe not for all franchisors and those that have in-house legal teams or more sophisticated, but certainly some of the smaller franchisors may want to share this modelling with franchisees to evidence the return on investment and how it will be achieved. And I think that really does present some risk to franchisors, as the franchisee will really likely place some reliance on that modelling. So robust and accurate modelling will definitely need to be taken by franchisors to ensure compliance with this obligation. Next slide. Thanks, Karina. So continuing on the theme of financial implications for franchisors, we have section 42, which provides that a franchisor must not enter into a franchise agreement unless it provides the franchisee to be compensated for early termination in certain circumstances. So this includes requirements for the franchisor to buy back or compensate franchisees for outstanding stock, any specialty equipment they've had to purchase or merchandise, and anything else that a franchisee really was required to buy in order to operate the business. Now, civil penalties will apply if the franchisor does not comply. So this section expands the scope of clause 46A of the existing code, which, like the previous slide, currently only applies to new vehicle dealership agreement and now applies to all franchise agreements. So in cases where the franchisor terminates the franchise agreement before it expires because the franchisee is withdrawing from the Australian market or makes significant changes to its distribution model, the compensation may go even beyond what's shown on the slide and include loss of profit, reimbursement of significant capital expenditure and costs associated with winding up the franchise business. So the introduction of this section marks a significant change under the code for franchisors and results in franchisors assuming significant risk and costs if the franchise agreement is terminated before it expires or if it is not renewed. Next slide. So now we move on from financial implications to non-financial incentives for franchisor compliance. We have section 75, which has been introduced and to essentially give the Australian Small Business and Family Enterprise Ombudsman the power to name franchisors who are a party to a dispute and refuse to engage or withdraw from an ADR process. It's important to note the Ombudsman does not have the power to publish the specific outcome of the ADR, as there are no legal obligations around disclosure of what has been agreed to, but it can publish franchisors' names in any way that it thinks appropriate to draw attention to the behaviour of the franchisor. This change intends to encourage franchisors to meaningfully participate in the ADR process. It's essentially a name and shame incentive. Next slide. So this then brings us to penalties, essentially why franchisors need to take the changes seriously. The government response recommended that all substantive obligations placed on parties under the code should have a penalty provision set at 600 penalty units. So as a result, provisions which didn't previously have penalties but include obligations now have a penalty. There are, on top of this, certain key obligations under the code which have substantially higher penalties. So these penalties are either essentially the higher of $10 million, the value of the benefit obtained that is reasonably attributable to the contravention, or if the value of the benefit obtained cannot be determined by a court, 10% of the adjusted turnover of the franchisor during the 12-month period prior to the contravention. So these are serious penalties, and these apply where there's a breach of section 33, so that's where franchisors have to make certain disclosure. Breach of section 42, that's the compensation for early termination, which I've just gone through. Breach of section 43, which is that reasonable opportunity for return on investment. And then breach of section 61, which is ensuring franchisees have the right to associate and form associations. So they are obviously seen as key obligations which franchisors must comply with, or they're going to be at risk of having a very high penalty if they're found to be in breach. Next slide. So whilst, as Karina said, the code is still in draft form and we're waiting on confirmation as to whether any further changes will be made based on public consultation, it is clear that the new code will present a substantial compliance burden on franchisors. This is especially in relation to the ROI and compensation provisions. So practical and efficient compliance is essential. And sorry, I'm doing a shameless plug here for Veramis. This is where Veramis's franchise platform could be very vital to a franchisor to ensure compliance. But essentially, that is us done. So we'll open it up to questions. I think I'm right on time.
Well, Megan.
Well done.
We do have working 2 o'clock.
Yeah, awesome timing, ladies. We do have a question. I think it's from Arania, from the NAB. Yep, she's asking, with the removal of the key fact sheet, will it be mandatory for brands to keep the disclosure register updated, as there are currently many that are out of date on there? And as a lender, we also rely on the info in the disclosure register.
I might take this one if that's okay, Karina, because it's a
please.
sort of a front-end question. So it's actually mandatory now to keep that updated. So just like franchisors have to go through and do a disclosure statement update, essentially key fact sheet and disclosure register needs to be updated as part of that process. And there's certainly no indication that will change.
So could I ask a question then on that?
Sure.
Could the brands be held? Well, for me, if something is showing as out of date online, that's a red flag for me. And would you be wanting to deal with that brand if they're not even updating their the things, their policies online? Is anyone going to be monitoring all of that? Like, so we know that it's being addressed.
Essentially, the ACCC is the regulator there. So there is that the monitoring, but whether or not individual franchisors are going to be picked up each and every time there is some outdated information, obviously due to resourcing, etc., that's not necessarily the case. But certainly that is just one of the addition, like you say, it's certainly a red flag if I was a franchisee looking at that franchisor and they haven't bothered to update that disclosure register, which is a requirement under the code. You query their compliance generally. And it's such a public-facing breach. So, yeah, I certainly encourage franchisors to be really on top of that, not just from the fact that it's a code requirement. It's actually just not a good look publicly either.
Yeah.
Thank you.
Yep, good question. Anyone else have questions? You don't have to type it in the chat now. You can just take yourself off mute and ask. Did the girls answer or everything?
Or is it shock silence, Helen?
Yeah, was everyone asleep?
People overwhelmed, possibly? I don't know.
I've got one, if that's okay.
Yes.
I recognise that voice.
Just how do you see the compensation clause playing out, or are you seeing any of your franchisors how they're sort of approaching that? I guess from a dealership perspective, I would imagine people have things in place already, but obviously, like from other industries, how do you think that would play out?
I did see, I guess some of my clients did have, I wouldn't say it would meet all the requirements of the new code, but there were certain processes and agreements post-termination of what they will buy back, because a lot of that was actually about protecting stock and brand and ensuring the franchisee wouldn't go out to market, particularly for some of our retailers. So I have seen provisions that particularly focus on stock and I've seen that play out. But obviously, this goes a bit broader than that. So it'll be interesting to see how our franchisors will do that and whether they'll treat it essentially as a buyback, if there'll be valuation type methodologies used, etc. I'm not sure.
Yeah, good question.
Yeah, it just feels, thank you. I was just going to say, it just seemed interesting from the context of renewals as well, because that just makes it more complicated from a franchisor perspective, where if there isn't a renewal or if for whatever reason the franchisor opts not to renew within, that 6-month time period, it just complicates it a lot from a compensation element in line with that section 43, which is a reasonable opportunity for a return of investment as well. It just murkies it up. So just very curious as to how that.
Yeah, you certainly would want to make sure that aspect is addressed at that termination, and whether that feeds into what actually gets paid as a result of a non-renewal or an expiry. The other thing that plays in my mind is, what if a third party comes along and wants to buy that franchise? How does that factor in? Because that obviously happens quite often, where the franchisee is actually receiving some value through a business sale. So yeah, there's certainly some complexities that really have to be worked through to make sure that the return on investment and the statutory requirement for buyback is factored in.
Yeah, we've definitely got that on the back of our mind, just in terms of sales, exactly what you've said. If there's refurbishment requirements attaching to that, whether as part of the sale a franchise partner opts to factor that into the purchase price, that starts skewing it a lot from a practical perspective. So yeah, it would be interesting to see how that plays out.
The one thing I will say, I've seen it successfully done where there's the franchisor rolls out an agreed valuation methodology. It was more in the context of buybacks, and certainly not under any obligation under the code, but there was an appetite to buy back franchises, and that worked really well because full disclosure was made. It was populated through the network, I guess, because there was a sense of trying to encourage some buybacks. But they engaged an independent. There was a level of independence and a set formula that was sort of in place for the whole network, and that seemed to keep things fairly stable in terms of negotiations, and so that's certainly something I'd suggest franchisors look into.
Yep.
Thank you. That makes sense.
Yep. Good chat. We have another question from William. I think ANZ. Could you comment further on trying to differ a renewal from a new contract for an existing franchisee?
Yeah, that sometimes becomes a bit of a grey area, because when the franchisor goes to renew an existing franchise agreement, very often they require the franchisee to enter into their new standard terms, and obviously the franchise agreement being a commercial document that reflects the terms of the business, that can evolve over time. So I think in practical terms, there's probably not really a great distinction in terms of the way it would operate. A renewal only being if you're renewing the term of an existing agreement and there are simply no changes to the document versus a franchise agreement that's entered into by way of renewal, but essentially it becomes a new contract terms that the franchisee is required to sign. Do you have anything to add on that, Megan?
No, I agree in terms of that, substantially the same wording, and I think there's a real risk with that, because I know franchisors have, as you've said, Karina, love to update their templates and get franchisees on new agreements. It may start to change that practice where existing agreements will simply be renewed to avoid that need for disclosure, etc. It'll be interesting to see how it plays out.
Yeah, great. Good question, William. So I thought I have a question that we can end on. We've done a lot of code of conduct review questions. What about we end on a little bit of a enlighten us on the licensing regime? Where are we at with that, Karina or Megan?
Yeah, that's currently out for consultation at the moment. I think it closes on the 8th of December, if my dates, my memory's correct. My personal take on it, I mean, it's still very much up in the air. My personal take on it, I think it's unlikely. The consultation paper by the Treasury has indicated that whilst the licensing regime may offer some benefits to the industry, it also comes with a range of issues, such as increased regulatory oversight, operational constraints, which could apply quite seriously affect the industry, and also transitional and ongoing costs. So I think my personal take is I think it's unlikely at this point in time, and particularly given there's already been quite a lot of upheaval with these recent raft of changes, but still very much up in the air. I'm not sure if you've got anything else to add on that, Megan. Yeah,
I agree.
Yeah, excellent. Great. Well, thank you so much, ladies. It was very informative. And when I send the recording to everyone, I'll also send you Karina and Megan's email contact details. Should you have any further questions or, you want to have a chat with the ladies, absolutely. Excellent. So that moves us on to next Lunch and Learn webinar, Wednesday, the 4th of December, coming up with Aegeus, and they will be talking about the two crucial issues facing Australian businesses. Interesting. So please log in for that one as well. Thank you so much to COWELL Clarke today again for taking the time out. You know, this could have gone on for hours and hours, as we know. And I have been privy to some of the lawyer workshops that we've had, and they've gone for hours and hours. That's for sure. So, yeah, very interesting times for franchising, but hopefully we've helped out here today. Thank you, everyone.
Thank you, Helen. Thank you.
See you at the Christmas parties.
Yeah. Thank you. Thank you very much, everyone, for listening. Thank you.
Thank you.
Thank yous. Lots of thank yous. It's good.
Yes.
I'm out.
Okay. Stop recording.
Hold on.